Bismillahirrahmanirrahim. In the name of God, most gracious, most merciful, my dear students of the English Legal Studies program, second year in the Faculty of Law, Banha University, peace be unto you. Today is the first lecture online. The lectures we studied before, we dealt with introduction to the study of international law and studied the first part in the book, which includes 2 chapters. Chapter 1 deals with the definition and nature of international law and the development of international law. The second chapter deals with the international law today. Today we will begin, today also we will study or begin studying in part 2. Previously we studied chapter 1 and part 2 concerning the nature of international law and the concept of the sources of international law. And today we will begin from page 31, chapter 2, dealing with various sources of international law. We'll begin with chapter 2, which deals with the treaties or conventions, or treaties and conventions as a source, a formal source of international law, and treaties as stated in Article 32 and Article 38 of the basic statute of the International Court of Justice. Treaties or conventions are considered the first formal source of international law. Article 38 of the basic statute of the International Court of Justice mentioned 3 sources as formal sources of international law. First, treaties. Second, international custom. Third, general principles of law recognized by civilized nations. Today, we will begin studying in some detail the subject matter of treaties or conventions as a formal source of international law. Treaties are to be concluded, any treaty to be concluded between 2 states or more, or between a state and international organization, or international organization and another international organizations, or more. There are, if we look to the parties to the treaty, we'll find there are bilateral treaties which are concluded between 2 states, trilateral treaties which are concluded between 3 states or among 3 states, and multilateral treaties which are concluded by many states in the world. And also there are global treaties or universal treaties which are concluded by most of the states of the world today, such as the United Nations Charter and the charters or treaties or conventions establishing other international specialized organizations, and so forth. Also, treaties concluded between states and international organizations are called treaties, but the Vienna Convention of the Law of Treaties in 1969 deals only with treaties concluded between states or by states. But there are other conventions dealing with treaties concluded between states and international organizations, or between international organizations and other international organizations. Anyway, in order to conclude a treaty, the procedures of concluding treaties and the methods and the steps of concluding treaties can be classified into many stages. First stage is negotiations between the states or the parties who are going to conclude the treaty. Negotiations and writing the results of the negotiations. The second stage is signing the written document or documents including the provisions which were agreed upon by various states parties to become parties to the treaty. The third stage is the final approval on the treaty or ratification of the treaty by the states concerned. And ratification will be or can be done or must be done in accordance with the legal rules usually stated in constitutions or constitutional principles of every state. And in each state, the higher law of the land would specify and determines the authority which has the power to ratify the treaty. For example, states do ratify the treaties through approval or by approval of the parliament, or states also through approval, like the United States, to treaties to be confirmed and final approval to be done by the Senate of the Congress of the United States. Also, and provided that there would be or must be approval of 2/3 of the members of the Senate present and voting. Also, in Egypt, approval of the treaties is done by the parliament and the signature of the president of the country. After the final approval of the treaty is given, there treaties should be published and so should be published in each state in accordance with the legal requirements of each state, and also should be registered in the Secretary of the United Nations, in the Secretariat of the United Nations. And the treaty which are not registered in the Secretariat of the United Nations cannot be used by any state before any of the organs of the United Nations. Therefore, the interest of each state part of the treaty to a treaty is manifested in registering it into the Secretariat of the United Nations in order to be able to say or to use it and to get it before any of the organs of the United Nations if there is a need to that, if a dispute arises, for example, or so forth, between that state or the other state party to the treaty. Also, after the conclusion of the treaties and after its entry into force, the treaty must be executed by the parties to the treaty. Performance of the treaty is important, and it is in fact there is a principle known as pacta sunt servanda. Pacta sunt servanda, that which means that pacts or pledges or promises must be fulfilled and performed in good faith. Once more, pacta sunt servanda means that pacts, pledges, or promises must be fulfilled and performed in good faith. So each treaty must be fulfilled, must be performed, and in good faith by all the members or the parties to that treaty. In fact, this principle requires that every state in the world and every party to a treaty must execute the provisions in the treaty in good faith, and therefore each one of the parties will fulfill his obligation concerning that treaty or convention. But even though there are some treaties that make effects which will extend to others who are not parties to the treaty or to non-parties to the treaty, such as, for example, a treaty which includes conditions in favor of a third person or a third country. In this case, the two states parties to that treaty must fulfill their obligations, provided that the third country or the third state will accept that benefit which comes from that treaty. Also, treaties which establish neutrality, also these are to be executed by the parties and also by other states in the world. For example, the treaties which establish the neutrality of Switzerland or any other neutral state in the world, such treaties are to be executed by all countries in the world and not just by the parties to that treaty. Also, treaties establishing a legal position which is permanent, for example, or which would come into effect and serves many countries in the world. For example, treaties concerning the right to passage in the canals, international canals like the Panama Canal, for example. Then all states must respect the freedom of passage into that canal, and therefore every state must respect that. Also, there is one important limitation concerning the limits of treaties execution, that is concerning just cautions rules and principles. The treaty, any treaty that is in conflict with any just cautions rule or principle is to be considered as null and void and has no legal validity at all. And the states must not execute it. And just cautions means, in fact, the peremptory rules and principles of international law or overriding rules and principles of law or preeminent rules and principles of law or international law, which all of them oblige all states in the world, and any state cannot and must not violate such rules and principles, and if any state violates such rules or principles, this will be unlawful, and the people who are responsible for such violations will be considered as committing international crimes and crimes against humanity. Therefore, I'll give you examples for that. For example, threat to use of force or the use of force is prevented and prohibited under the Charter of the United Nations, and is now considered as the prevention and prohibition of the use of force or the threat to use force by a state against any other state is now considered a rule or a principle included or coming under just cogence, which is, it means that the prevention and prohibition of the use of force or the threat to use force becomes an peremptory rule or principle of international law, preeminent rule or principle of international law, or overriding rule or principle of international law that must not be violated, and the state violates it becomes the state which violates it becomes a state doing a lawful thing and must be condemned and must be punished through competent international organizations such as the Security Council or the General Assembly and so forth of the United Nations. And also the people who are responsible for such violations in that states must be presented to the international criminal courts, such as the Permanent International Court, the Permanent International Criminal Court, established in accordance with the Charter, the Charter of Rome, and also other international criminal courts to be established in that respect to punish the violators of such rules. Therefore, it becomes very clear that just cogence principles and rules are obligatory and overriding rules, peremptory rules, preeminent rules and principles that are to be respected and not violated by any state in the world. Therefore, in concluding treaties or executing treaties, if anything concerning that will be including a violation of a just cogence rule or principle, then that would be unlawful and a great crime against humanity, and the person who is doing that must be presented to be punished by the competent international tribunal. But anyway, treaties in general, if they are fully correct, must be executed by all states parties to it. Also, with regard to that, treaties may be amended, and that amendment would come through either negotiations and express approval of that amendment, or through customary practice among the states parties to the treaty, and this happens sometimes, for example, concerning the United Nations Charter was amended customarily in cases such as the use of veto power by a permanent member of the United Nations, when in fact the Charter of the United Nations itself includes a provision that with regard to substantive matters there must be approval of 7 states of the members of the Security Council before 1968, or 9 states after 1968 and the amendment of the Charter, including the votes of the permanent members, including the votes, the concurring votes of the permanent members. Concurring votes of the permanent members means that the 5 permanent members of the United Nations Security Council, all of them must approve that decision or resolution in substantive matters. But what happened in reality, beginning from 1946 and afterwards, some of the permanent members abstained from voting, but they suggested that their abstentions must not be considered as a veto power, and that was accepted during the practice of the Security Council. And in 1947 the president of the Security Council at that time, which was the Syrian representative in the Security Council, declared that this became a customary rule, that the abstention of a permanent member from voting is not to be considered as a veto, and that allows the decision to be issued if obtained the required majority of other states members in the Security Council. And this practice is still exercised till now and is considered as a customary amendment of the Charter of the United Nations. Therefore, treaties can be amended by express meaning or by express approval of states, or by customary practice of states. Also, treaties will end if the period stated in the treaty for its being enforced ended, or if the parties agreed to end that treaty and or terminated. Also, a state may withdraw from the treaty and cancel its approval. But in this case, the state must carry out its obligations necessary until such act be approved by other states party to the treaty, or another resolution or another solution to be reached in that matter. Therefore, treaties are in fact the first formal source of international law as stated in Article 38 of the Basic Statute of the International Court of Justice. And next time we will study international custom or customary international law as the second formal source of international law, customs or international customs. And today I ask God, Almighty Allah, to help you to do your best and to study as hard as possible. And God willing, you all, if you do your best, will be successful. But if you do not do your best and you do not study, then you do not blame except yourselves. I hope that you will do your best, and that we also hope all together that what the world now suffers from, God will remove it and will be merciful to the humanity at all, and to the people in Egypt, and to all the peoples around the world. Thank you so much. Goodbye, and see you after in the coming lecture with God's willing. Thank you.